for the record, spell your first and last name, please.
Jason Rubin, Jasonrubin.
Proceed, please.
Thank you. Mr. Rubin, can you tell us what your occupation is?
Sure. I am a licensed private professional fiduciary as well as a forensic CPA, certified public accountant.
Can you tell us in English what that means?
Sure. So I essentially have two careers. One is I administer trusts, probate estates, and conservatorship estates, and the other I deal with financial and accounting issues in the litigation arena, where I testify as an expert witness on such issues, basically in corporate, trust and estates, and other types of matters, as well as conducting fraud investigations.
Can you give us a brief summary of your background, experience, education?
Sure. I graduated from Cal State Northridge with an accounting degree. I have worked with major law firms and CPA firms such as Price Waterhouse, Munger, Tolles & Olson. I also worked at CBiz. And I have about 34 years as working as a forensic accountant and about 20 plus years acting as a private professional fiduciary.
And you made a little slight comment, it seemed like on CBiz. Why did you do that?
Oh, because the DA's expert, Marie, works at CBiz, but she didn't work there when I was there. I think she started in 2002 and I left in 2000.
Ms. Eversbacher?
Ms. Eversbacher, yes.
How did you get involved in the present matter involving the estate of Fabio Sementilli?
Yes, I was nominated by, I believe, Fabio's son Luigi, and the court had appointed myself and Maya Rubin, who's also my wife and partner, as co-administrators of the estate.
And under what circumstances are you usually appointed co-administrators? Does that have anything to do with Mr. Sementilli having been deceased or the defendant being incarcerated or what?
It was both. Essentially, there was no one, I'm presuming there was no one there who could serve, so they usually what happens is the court will appoint a private professional fiduciary to act as administrator of the estate if no one is willing to serve or
and
can't
you're
serve.
still the administrator of the estate?
Yes.
Did you ever have contact with Ms. Eversbacher?
Yes, I did.
Did she contact you?
Yes.
Can you tell us what the subject matter was of her contact?
The subject matter was regarding the assets of the estate, and she was putting together a calculation with regard to the assets of the estate, and we learned that it was death versus divorce.
Your Honor, I have Exhibit 126 in my hand. May I put that on the?
That you have.
Yes. Thank you.
Is your screen pretty well on there?
Yes, my screen is up. But
You can do it one if you want.
Mr. Rubin, this is Exhibit 126. Do you recognize it?
yes, I do.
And is that a divorce versus death benefit estimate, which is the title that was prepared, as far as you know, by Ms. Eversbacher?
Yes.
And is this what she consulted with you about concerning the preparation of that document?
Prior to her preparing the document, she consulted with me regarding the assets of the estate, which are incorporated on here.
And did you review the document before talking with her about it, or did she talk with you about it before she completed it?
She talked with me about it before she completed it.
And did she discuss with you the assets and the various items that are listed on that document?
She discussed with me assets, which I could see some of them are on the document, or the assets are on the document.
And do you recall the advice that you gave her concerning that?
Well, during our conversation, prior to this document being prepared, I did mention to her, like as I mentioned to others, that I always felt that Fabio was worth more. I'm sorry, there was a greater divorce benefit than there was a death benefit with regard to Fabio.
And what did you base that on? Well, let me looking at the document up there, what items did you disagree with?
I disagreed with the P&G stock options as well as the post-death separation, compensation, as well as some other items that were not put onto the document.
And one of the items that was not put onto the document, did that include alimony?
Yes.
And did you make that known to her?
At the time, yes.
Okay. Now, concerning the stock options, can you tell us, and referring to the chart, where you believe her calculations were inaccurate?
I'm sorry, repeat that again?
Regarding the stock options, can you, referring to the chart, 126, tell us where she was wrong concerning the options, in your opinion?
Sure, she was wrong that this chart was supposed to be prepared as what Monica's mind was January 2017.
Which was what?
January 2017. And this,
Jack Benstein's facts and evidence.
That's overruled.
Is that the date of the murder of his death, Fabio?
correct. So as of January 2017, the value of those options were about $74,000, and what happened was the stock options, the price of Procter & Gamble had gone up over time, and then these options were cashed out in 2024 where the stock had doubled. So the value in 2024 was $935,000, but in 2017 it was only $74,000, so that's where my major disagreement was with the chart.
All right. And why did you calculate the item at the time of Fabio's death?
Because at the time, I was looking at what would have been in Monica's mind at that time, and there's no way it could have been $935,000 because that's it's a crystal ball, looking out 8 years or 7 years from January 2017.
So if those options had been exercised on or about the date of the death of Fabio Sementilli, the value would have been what?
I think it was around $74,000.
And the figure again that was put on the chart by Ms. Eversbacher?
$935,814.
And that was the date that the estate actually exercised the options in what year?
2024.
At any time after the death of Fabio Sementilli and up until the date of the arrest of Ms. Monica Sementilli, to your knowledge, was there any attempt made by her to cash in on those options?
Not to my knowledge.
In fact, the estate itself, which you were administrator of, until you got a letter from Procter & Gamble, were you even aware that those options existed?
I was not aware those options existed until approximately 2023.
And at that time, there was a limited period, am I correct, that if you did not exercise them on behalf of the estate, they would have expired?
That is correct.
So they were exercised at that time, is that correct?
Yes, 23 and 24, yes.
And there were several stock options, separate options, is that correct?
Several tranches of stock options.
So are you using the total of what those options would have been worth on the date of his death versus the date of 2023 or 24?
Yes, I'm using the total of the three tranches that were exercised and cashed out in 2024 to come up with the $74,000 on the date of his death versus what was cashed out of $935,000 in 2024.
Now, in addition to that, you said the chart included the post-death benefits that were provided to Monica Sementilli and her family. Is that correct?
Yes.
And that amount was what?
It shows here is $50,271.
And why did you not include that in your calculations?
Because I don't think Procter and Gamble or anyone would have known. I'm sorry, I don't think Monica would have known, or anyone else would have known that if Fabio died, she would have received this post-death compensation.
In other words, these were figures decided on or amounts by Procter and Gamble to assist Ms. Sementilli and her family that were only calculated or offered to her after the death of Fabio Sementilli, correct?
Yes.
To your knowledge, were those specific benefits in any way included in any of Procter & Gamble's plans or brochures that would have been known to Ms. Sementilli on the date of his death or before?
Objection, speculation.
That's farm system.
To your knowledge, well, do you know when those benefits were first decided upon by Procter & Gamble?
It may have been January or February 2017.
And is it your understanding that those benefits were not put into place until after the death of Fabio Sementilli?
Yes, that was my understanding.
Finally, Mr. Rubin, there is a entry up there that is labeled, I think it's number 3, LG Consulting. You see that?
LGI Consulting.
LGI Consulting. And do you see the amount that is listed there under estate and divorce?
Yes.
Do you know how those figures were reached in speaking with Ms. Eversbacher?
Yes, I believe those were amounts that were in a bank account for LGI Consulting.
And LGI stood for Luigi, Jessica, and Isabella. Is that correct?
I believe so.
Okay. Do you know what those, did you research what those amounts were based on?
Well, the $9,464 was based on, I believe, an amount that was in a bank account for LGI Consulting.
Do you know what the source was of those figures or those amounts?
I believe that the source was the monies that LGI had received from Scissor Boy, who Scissor Boy had a contract with Procter & Gamble or Wella for an app, and so Scissor Boy would give Fabio approximately 25% through LGI of the monies that were received from him through Procter & Gamble and Wella.
All right. And did you research or did you have or uncover the figures, the amounts for the past 3 years, for instance, on the tax returns that was going into that account as a result of this arrangement between Fabio and Scissor Boy?
Yes.
And what was those amounts approximately?
It was anywhere from like 50-something thousand to a little bit higher. I don't have, I could look on my, I don't have the amounts in front of me.
Do you have it with you on your...
But what I do, yeah, let me look at my, sorry, file on my phone.
Did we allow you to bring your phone in as a special exception to the rule so we're not all jealous of you?
Yes.
Okay.
So in 2015, they received $63,137, and that's what, I'm sorry, that was what was reported on their income tax returns. And then in 2016, they reported $54,886 on their income tax returns as being received.
Was one of your jobs to maintain whatever funds were going into the estate at the proper value so that the estate could benefit, if possible, after the death of Fabio as before?
Yes, my job was to attempt to collect marshal the assets of the estate and collect any income that should be received into the estate.
For the beneficiaries?
Yes.
And in doing so, did you investigate what the source was and what the relationship was between Scissor Boy and Fabio Sementilli?
Yes, I did.
And what was that?
Apparently, there was a relationship where Fabio or LGI Consultings would receive, I don't know if you want to call it this, but a so-called kickback of monies that Scissor Boy received from Procter & Gamble or Wella. And that deal was approximately, he would get up to around 25%, meaning Scissor Boy would pay 25% to Fabio or LGI Consulting.
And was it your goal after the death of Fabio that that amount should continue?
Yes.
And did Scissor Boy agree?
No.
Did they indicate why they disagreed?
He pretty much said when Fabio died, the deal died with it.
And did you consider filing litigation against Scissor Boy to compel them to continue to pay that amount?
We considered and did file litigation.
And what was the result of that litigation?
The result of the litigation was unfortunate, but we got $25,000. The problem is that one, it would have been very costly to litigate, and two, there was no prevailing party, there was no like written agreement for a prevailing party clause provision. So the cost, it would have been a bunch of, would have been a lot of discovery and a lot of costs involved, and we didn't want to burden the estate with the costs. And plus, also it would have been difficult to collect because Scissor Boy was a Canadian citizen.
So, as a practical matter, while Fabio Sementilli was alive, the amounts that you've testified to would have continued, as far as you know, into LGI, correct?
Yes, but I believe those amounts would have been greater than the ones showing.
And in essence, you were informed that upon the death of Fabio Sementilli, those amounts would no longer be paid because they depended on his being alive and being involved in the relationship between Wella and Scissor Boy. Is that correct?
Yes.
Did you later find out that after Fabio Sementilli died, that Scissor Boy made a separate contract with Wella without him and collected additional funds from Wella?
Yes.
This thing.
Move this straight.
Very well, Your Honor. Thank you. Ms. Little. I'm sorry. Can I just deal with one second? I don't think I asked you the final question of after including the items that we've discussed. Well, first of all, did the chart include alimony?
The chart prepared by the DA's expert, Marie, no, it did not.
And did she discuss that with you at all?
We never discussed the chart. We discussed items that were in the chart, but not the chart itself.
So you developed or prepared a chart, I believe, that involved the discrepancies that you have discussed with us today. Is that correct?
Yes.
And excluding alimony, well, let me ask you this. What was the figure that Ms. Eversbacher had on her chart as the advantage to the defendant upon the death of Fabio Sementilli versus had he lived and they divorced?
Yeah, she put on there that the total death benefit greater than divorce benefit was $1,506,081.
If you corrected that amount by the mistake you say she made in calculating the value of the option as of 2023 or 24 rather than the date of the death, what would the difference have been?
I believe I have a chart right here.
That's all right. Sure.
The difference of the overvaluation of stock options was $495,011. So it would have reduced the $1,506,081 by $495,000. So it would be approximately $1 million.
And did you calculate what the approximate difference would be if alimony had been figured into the calculation due to that would have been due Ms. Sementilli upon the death, upon the divorce between her and her husband?
Yeah, I incorporated the information received from the family law expert. He said it was $900,000 that Monica would have received in alimony over 10 years, or I'm sorry, it's $90,000 a year for 10 years should there have been a divorce.
And if you had figured those figures and included them in the death versus divorce chart, what would the amount have been?
So if you deduct the $900,000, then you're left with that the death benefit over the divorce benefit would have been $100,000.
And would you agree that that figure could depend on a lot of factors, how much alimony you get, such as the length of the marriage, what the salary, whether or not Ms. Sementilli worked on her own afterwards or not, and other factors?
Yes.
And you calculated on a 10-year period, is that correct?
Yeah, on the period based on the family law expert, yes, the 10-year period.
And if they if they had been married for 20 years, she may have been able to get alimony greater than that, correct?
I don't know.
Okay. Would, as far as you know, alimony have been based or corrected in some way if Mr. Sementilli's annual income had increased?
I'm sorry, repeat that again?
If his income had increased each year, to your knowledge, based on your experience, would that have at some point increased the amount of alimony?
Yes.
Because of the increase in the salary?
Yes.
Did the chart include anything involving alimony?
No, it did not.
And did you disagree with that?
Yes, because the chart is titled divorce versus death benefit, and it's calculating total death benefit greater than divorce benefit, and one of the divorce benefits should have incorporated alimony. That should have been a component in there.
Would you agree alimony can be in a range depending on a lot of factors?
Could have been what?
A range of numbers.
Oh, right. Yes, there could have been a low range to a high range.
Was that even put into the chart?
No, it was not.
Thank you, Anna.
Now, Ms. Bailey.
Okay, thank you. Good afternoon. So you are a financial accounting, did you say CPA?
Yes.
Okay. And an administrator of trusts and probate matters, is that right?
Yes.
So in this case, you were assigned originally as the probate attorney for Fabio Sementilli and Monica Sementilli?
No. To correct, probate administrator.
Administrator, okay. So that's one side of your career path, is that right?
That is correct.
And then the other side is financial accounting and litigation?
Financial and accounting issues in the litigation arena as a forensic accountant.
What you're doing right here, kind of, does that involve what you're doing here, the testimony that you're giving?
The testimony I'm giving is related to the probate estate, the assets of the estate, and the chart that was provided to the assets in the chart that was provided to the defense about 4 or 5 months ago, which they asked me about.
Now, do you consider that since you're administering a probate estate and you're giving opinions in court as to death versus divorce, do you consider that a conflict of interest?
No.
Why not? You're testifying for the defense as their probate attorney. Do you consider that a conflict of interest?
I'm testifying on behalf of what has been provided to me, and also in the probate code. There's I forgot, I could look up the code, but there's something in the probate code where I'm required to use my special skills in probate estates whenever asked.
To administer the will, trust, or probate, not testify in a criminal court in a murder trial. Is that right?
Well, I've been asked by you, and I've been asked by the defense to provide information for the past 7-8 years, and that's what I've done.
Okay.
I have not been one-sided or the other.
All right. Over the course of the years, then, since the one of the parties is deceased and the other one has been charged with this, who do you communicate with as far as the family?
I've communicated with Luigi. I've communicated with Monica's sister.
Okay, so I'm just saying, in general, you communicate to all sides to let them know what what is going on with the estate. Is that right?
Yeah, so we file probate accountings and the like.
Okay. If I may, Mark, my next in order is, I'm not even sure now. And by the way, when was the last time that you communicated with Luigi?
About 3 to 4 weeks ago.
Okay, what was that about?
He had some questions about some issues related to the estate.
Your next is 281.
281, if I can mark as 281, and it is it's entitled Reconciliation of CBIZ, and it's a diagram that resembles R126.
Very good.
Is this your report that you were referring to, the same data, and that's 281, the same data and chart that was prepared by Ms. Eversbacher, what we saw on 126, is that the same chart that you made your corrections or your observations in red and some notes at the bottom, right?
Yes.
Your Honor, could we just approach the one?
Sure.
All right, so the first topic that we were talking about was you made some corrections, I think down here in the bottom, what you testified to, the points that you testified in court, is that accurate? The over-evaluation of stock options. Is that
Yes.
one? And then the improperly included post-death separation, that's 2, right?
Yes.
The amount of $90,000 per year for 10 years provided by the family law expert, right?
Yes.
Okay, and then the failure of the expert to include the LGI consulting as an asset, that, right?
Yes.
Okay, so then that was your calculation that you came to, then that the death benefits tipped in favor of you get more money if you were to divorce them.
Yes.
Okay, got it. So when we talk about the stock options, and I'm not going to spend a lot of time, but you were given all these documents. When you administer an estate, then you're given like all the pertaining financial documents and have to reconcile them and go through them all and find out what it entails. Is that correct?
Well, we talk to people and we're given information, and we administer the estate we administer the assets of the estate.
So wouldn't you get, though, as the administrator of the estate, the fact that Procter & Gamble had given him Fabio's stock options?
We didn't get that information until later on.
Okay, so no one mentioned in the family stock options, you didn't look at the Procter & Gamble documents that showed stock options?
We didn't receive any information regarding stock options until 2023.
All right, so I have an email from a Donald Willis. Do you remember getting an email from a Donald Willis from Procter & Gamble?
No.
Okay. And, well, I can mark this if you like, but would you like to refresh your recollection and look at this?
Sure.
Okay. And this was an email sent on February 25th of 2022. You can kind of go through the chain. Was backwards.
Yeah.
Okay.
I haven't read the document yet, so I'm just trying to figure where to start.
Okay.
Okay.
All right. So you saw there that in February of 2022, and that was February 25th of 2022, Procter & Gamble contacted the DA, which then went through Luigi, saying, hey, there's these stock options. They're going to expire. What are we going to do? You saw that part, right?
Correct.
And then Luigi sent you an email, Jason Rubin, CertifiedStrategies.com, that's right?
Yes.
Okay, so Luigi sent you an email then on February 25th of 2022 letting you know about the stock options then, and that some were expiring.
Correct.
Okay, so
And it looks like we sent an email to Procter & Gamble inquiring about the stock option.
Okay, I'm just showing you, that was actually February 2022, if that refreshes your memory, not 23.
Okay, well,
All right, that's okay. So in February of 2022, then you contacted Procter & Gamble, and then they gave you the information on the stock options then.
yeah, that's what it shows. Yeah.
Well, no, I'm asking you. I mean, you're the.
Yeah, I mean, apparently, we have a lot of estates that we minister and everything, and so it happened at that time at 22. We asked about it, but we didn't hear back for a while.
All right. So at some point you did hear that. Was it your understanding then that Fabio had 5 sets of stock options?
I believe there were 4 because they were exercised in 23, and then 1 and 3 sets in 2024.
Do you know for sure?
I recall that those were the ones. I have to go back and look at my records.
All right. If I could mark a 2-page document, it's an email to Jason Rubin regarding PNB equity grant. Now this one, there's a date on here, January 20th, 2023. Did you provide this then did you provide this to,
There you go. It's right here. So those were the ones that were exercised in 23. I'm sorry, they received the payment in 23 for 22. So maybe I got the timing a little off.
That's okay.
But it's.
that's okay. I'm not holding you to that. This particular document that in 2023, you got this from Procter & Gamble?
If I received it, I have to go back and look at my records.
Okay, the last page here, a Tanya Wine, Stock Plan Administration, Procter & Gamble.
It's possible. I have to go back and look.
Would you like to look at this?
I saw it on this, but again, you asked if I received it, and I'd have to go back and look at my records. I may have.
Are you Jason Rubin, administrator for the Fabio and Sementilli estate? If you're looking at 6324 Avenue Suite 1470, Woodland Hills, 93667.
That's me, and that's the letter that's written. You asked me if I received it. Again, I may have. I have to go back and look at my records.
Okay. Well, let's assume that you received it.
Okay.
All right. So in there it says, in February 2022, you exercised some of the equity grants awarded to Mr. Sementilli as the administrator of his estate. And then you got the payment. In January 2023 was deposited, right? So that would be 1 set of stock options, because they were already exercised, right?
Yes.
So is it fair that when you found out there were stock options, one of the sets was expiring, so you exercised it, that's what this is referencing.
Correct.
That's 1. Down at the bottom, Procter & Gamble lists 4 more sets, right? Is that right?
Yes.
Okay, so there's a total of 5 sets of stock options then. Okay?
Yes.
Is that right? All right. So the next one that's coming due then, 2/28/23, 13, and it's vested. So by it saying it's vested in 2016, is it your understanding that these stock options have a 3-year vesting period? Because it shows you right there.
For the 640 shares granted.
All right, so 3-year vesting period. And that means for stock options, he's given the options. He can't do anything with them for 3 years until 2016. And at that point, now he can exercise them and get the over money if the stock's gone up.
Right, the price higher than the grant price,
Right.
the share price.
Right.
That's correct.
And then they also have an expiration date, and each year the options being granted is a year later, right?
Yes.
Okay. So now the second set then, at the time of the death of Mr. Sementilli, these were vested, meaning the defendant could have, let's say on 1/23/2017, he didn't die. She divorced them. We're using that date. So these options then, she could turn in 640 the overage, whatever, they've gone up in value, and she could have exercised those in 2015, but on the date of the separation on 1/23/2017, she could have exercised them.
Yeah, it would have probably been worth about $6,400.
Okay, $6,400 is what she would have gotten.
Right.
All right. The other ones, the other three remaining, they're not vested yet. She can't do anything.
They became vested right after the date after Fabio died.
Because he died.
Correct.
So when he dies, they're all vested. She can get all that money right then.
Correct.
Right. But if she divorces him, she can't get those because they're not vested yet. The last three.
Well, it doesn't have a vesting date on here because he had died. So the question is, what would the vesting date been if he was still alive? And if you're presuming that it's 3 years, so the options for 3,879 shares would have vested in a month after he died.
A month after he died.
And then after that, it would have been vested a year and a month after he died. Sorry, the 4,247 shares
Right.
and the 4,299 shares would have been 2 years and a month after he died.
And that's all after he died and after he died.
Right, after he died. And
So there's a big jump though when let's say she divorced him though, as I was saying. The 640 shares, she can get that if she divorces him on 1/23/2017. That's the money she could walk away with. All right. The other stuff she has to wait for because it's not vested.
well, the first one, I mean, the one that would most likely vest in February 2017, that would have been a year. I mean, sorry, it would have been a month. So divorces usually take about 1 to 5 years. I've seen 7 or 8. So,
But you're not an expert on that, right?
I've testified in family law court as an expert, but I do very little work in family law. So, sorry.
Okay, so we'll leave that to the family law attorney.
Right,
Okay,
exactly.
All right.
Exactly.
So again, that's my question is she couldn't touch those shares. The last three, she couldn't touch those shares if she were simply to divorce Fabio on 1/23/2017. That time frame.
That goes beyond my expertise.
Well, you're testifying as an expert here.
Wait,
You just
wait.
testified.
That's argumentative.
It's his thing.
Okay, did you just testify to stock options on direct exam with Mr. Levine?
Yeah, but you asked me a certain legal question.
That's not legal. I'm asking you a question about stock options. Do you not?
Can you repeat the question?
Sure. These stock options, which you just testified for the defense on direct exam, what I'm saying is these last series of stock options, assuming the 3-year vesting, which we can see above, is what Procter & Gamble appears to be doing, they were not available for Ms. Sementilli to cash in had she simply divorced Fabio Sementilli on 1/23/17.
Well, it would have most likely been something that would have been negotiated along with the divorce while it was going on, or resolved through the divorce
That's
process.
non-responsive.
Well,
It's also speculation. Stand on that ground.
It's not available. Correct. It's not vested yet. It's a yes or no.
well, it wasn't vested. Well, it apparently wasn't vested on the date of death, and a month later, I mean,
Objection non-responsive.
It's his thing.
All right. Do you not want to answer that question?
I answered your question. I said it was not vested
Thank you.
until a month later. It would have been vested for
That
that
wasn't my question.
first tranche. Yeah, you did. You asked that question.
All right, so we're going to move on. So we have, and you can see how the stock options jump from the time that they're vested in 2016 at 640 shares. It jumps into the thousands. Now, all of these shares, again, that we're looking at now, you go from 640 shares, and now you've gone all the way up to 4,299 shares. So all of these shares, if Fabio dies, are automatically vested, right?
Yes.
And Exhibit 187, the letter from Procter & Gamble, you're familiar with this letter again. Do you remember receiving this one?
Can you
Uh-huh.
condense it? Yes.
Okay. So again, that shows then the vesting, because he died, they all vested. So all that money became readily available.
Correct. The vest date was a day before from the other letter. But,
I'm
yeah.
sorry?
The vesting date was a day before from what shows the vesting date on one of the other documents you showed me from Procter & Gamble.
Right. 123 is the day he died, so they vest the day he died, but Procter & Gamble put 124 in some documents.
Correct.
Okay. All right. Now, also, so Procter & Gamble notified, and it got to you in 2022, we determined that these stock options were available and needed to be exercised, at least that first of 5 sets, because they were expiring. So then, did you exercise, meaning, I don't know if the word is turn in, but you exercised those right away because they were going to expire, right?
Yeah, we exercised based on the information that was provided to us.
Okay, that first set.
Right.
So now you know that there's stock options that Fabio has, because now Procter & Gamble has notified you as of February 2022 that there's all these stock options out there.
Right, and then we get a letter in 23 and then one in 24.
So you get a letter, I'm getting that, in 2023, if I could mark as people's 283, it's an email, 2-page email.
All right, so Mark.
And again, this is to ION, Stockhawk. I say that now, he's going to Stockhawk, STOCKOPT. Oh, do you remember getting this email? At the bottom down here, February 12th, 2024.
I can't see the entire document.
There you go.
Annual or something like that, yes.
Well, do you remember this document?
I have a large practice. I administer a lot of trusts and have a number of forensic cases. And like I said, I remember probably seeing this document, and, you know, I didn't go back and study everything prior to testifying today.
Okay.
So, you know, I see a lot of documents every day. I get tons of emails. And if you look at my phone, I'm sure you see like 300 emails today. It's just, I don't recall everything. And like I said, I didn't study everything on this case.
You knew you were going to testify today about stock options, though?
Yes.
But you didn't review the stock options information regarding that very topic?
I reviewed information and documents that, some of the documents we received in order to do the calculations I made.
All right.
To determine the value.
Okay, so you get a letter then from Procter & Gamble in 2024, February 12th. It's sent to you on your email, and they're telling you, hey, there's this second set of 5 stock options, and they're going to expire. This is the second time you guys have been notified for this. They're going to expire on February 28th, 2024. Someone needs to exercise them. They're going to expire in 2 weeks. You got that letter, right?
Yeah, and we exercise it.
All right. Now, and also in their letter they say, this is a courtesy only, and P&G is under no obligation to provide any further notifications or reminders of upcoming expirations of any other options or equity awards. Right?
Yes.
Did you guys forget about this second set of options?
We exercise those.
Because you got a letter, right?
We were in the process. I'd have to go back and look at our files, but I know we exercise them, and all you're trying to do is just attack me for whatever reason. I don't know what this has to do with coming up with the value.
Sustained and stricken.
You knew you were going to testify today about stock options, right, sir?
But as to the value of the options for what you had put on in 2024 of $965,000 or $935 versus what the actual value was of $74,000, which misleads the jury as to the financial motive.
Objection, non-responsive, no objection.
Yes.
Stricken. Sir, try just answer the question.
Sure.
All right. So, you understand because you're an attorney, right?
No, I'm not.
Okay. You have no lawyer.
No.
Okay. So, you understand in a courtroom, There's direct exam, and then the other side is cross-examination, right?
Your Honor, this is argument.
Alright, so on this Procter & Gamble then, again, February 14th, they sent me a notice saying, hey, probate or terminate. These current options are going to expire in 2 weeks. So
I'm not a probate attorney.
what happens if they expire?
Those options were cast. The options, if they would have expired, it could have been, I don't know. It could have been zeroed out. I don't know. But those options were exercised.
Objection?
You asked a question. I just answered it.
Sir.
Sorry.
Your Honor.
No, excuse me, counsel. Excuse me, counsel.
Now you're going to object on relevance.
That's overruled, and so is your objection. We're being non-responsive.
Okay, my question to you is very simple. You administer probate, probate administrator. You administer wills and trusts and things of that nature, correct?
Yes.
You've dealt in stock options before, correct?
Yes, I have.
Okay, you've had to exercise those stock options on the behalf of an estate before, correct?
I don't think we've exercised. This is the first estate where we exercised stock options.
Is that why you're almost missing deadlines to exercise them?
We didn't miss any deadlines.
Because you got notified by Procter & Gamble that they were going to expire, which means no money, right?
We didn't miss any deadlines, and I would have to talk to people in my office too.
Okay. All right. All right. So, when you talked about the 900,000, you incorporated that from, you want to turn it up? The 900,000, you incorporated that from, down here you said that failure, amount of 90,000 per year, 10 years, family audits. You just accepted the numbers from a family law attorney, Mr. Malatesta, correct?
Yes.
Did you talk to him?
No.
Are you an expert in family law?
For that situation, no.
Okay. So that $900,000 that you're disputing, Ms. Eversbacher, is that just based on what Mr. Malatesta had in a report?
That's correct.
Okay. This LGI consulting, did you have financial statements from LGI consulting?
I had an income tax return that was an income statement.
No, I meant financial documents from LGI consulting, the income tax return.
Well, that is a financial document. It provides, it's an income statement that's on their tax return that's Schedule C.
Okay. Did you have any additional financial documents from LGI consulting?
No.
Do you know anything about LGI consulting?
From what I've read,
What have you read?
I've read that there were emails and like as I testified before that Fabio or LGI Consulting would receive monies from Scissor Boy up to about 25% based on what Scissor Boy received from Procter & Gamble or Wella related to an app that he provided for them.
And where did you get the 25%?
I got that from, there were emails.
From
I think it was from Scissor Boy to Monica, as well as other information that I received.
Okay. So if I could mark as people's numbers, 83? No, 84.
Yes, what is it, please?
It's an email from Grant, R-M-U-N-D-T, to Monica.
All right.
All right? So an email, you recognize this email then?
Yes.
All right. So in that email, Grant, is he the owner of Scissor Boy, to your knowledge?
Yes.
All right. So basically, isn't it true that Grant went into a consulting business with Fabio, where Fabio worked on one part of Scissor Boy app, and he would get paid for that, right?
There was another email that I recall reading where, I don't know if Fabio worked for it, but it was based on a percentage of what Scissor Boy would receive, other than this email.
Okay, so in here you see that the share is about $3,125 a month for your share, and that's Grant writing to Monica on February 8, 2017, right?
Yes.
So roughly about $3,125 a month for Monica from Scissor Boy money.
Which is obviously less than they even reported on their tax return. So, I mean,
Objection non-responsive. Move to strike.
Yeah.
that's what the document says, but all I'm saying is that amount is less than what was reported on their tax return.
There's stricken. There's no question pending yet.
So you gave that number a share, that number, you put on your document here, $365,000 from Scissor Boy, right here, as an asset, right?
That would be the value of the cash flow
Okay.
expected to come from Scissor Boy.
Expected to come from Scissor Boy based on what?
Based on documents we received that the defense had received in a subpoena from Procter and Gamble of the monies that were paid out to Scissor Boy.
Okay, so you understand that Procter and Gamble pays Scissor Boy a large amount of money. That money doesn't all go to Fabio. Fabio has a small piece of it for his app. That comes out to about $3,000 a month. Did you understand that?
I understood that there was an app and there was monies that would be paid to Fabio, and there were several emails I reviewed. I don't have those in front of me, but and based on, so what I did was, I'll just tell you how I did my calculation. I'll explain it to the jury. So what I did was I took the monies that Procter and Gamble had paid to Scissor Boy over like a 3 or 4 year period, and I took 20% of that. And
Why 20?
why 20? Because sometimes it would say he would pay, it may be less than 25% and be 15, so I just took 20%.
So you just picked a number?
It wasn't picking a number, it was just using kind of like an estimate based on documents I had read.
All right.
And then what I did was, so over the years, let me look at this here. So for example, between the year May 1, 2016 and April 30th, 2017, Scissor Boy received $578,000 from Wella, and that was 60% greater than the $360,750 he received in the prior year. So these amounts keep going up, and in fact, yeah, it was a 60% growth rate. So what I did was I took 20% of that amount, which is comes out to $115,000. That would go to LGI Consulting, and then I capitalized that to come up with the value of the cash flow. And I came up with a range of values between $385,500 and $578,000, and I took the low end of the range and applied it to the chart.
Okay, so all of that calculation, you determined that $385,000 would go to Monica in the event of a divorce based on LGI consulting that money to Scissor Boy.
Well, what I said was that's a correction to the chart where it should be added as an asset, but yes.
All right, so same thing I just
Yes.
said though. Okay.
Yes.
But what if I told you that it's not that dollar amount, and you said that, yes, Wella paid Scissor Boy this at $500 and some thousand, but only $61,375 from that same time period was the deposits for Fabio and Monica. That changes everything, right?
Yeah, if that amount, the $61,000, is what they actually received, then yes, that would change. But I don't know.
You don't know.
Right? Do you know?
Objection, not responsive.
It's sustained.
Move to strike. I'm not a witness or an expert testifying. You understand that?
Well, if you have the information, then provide it.
So are you the probate administrator for this estate?
Yes.
And you're testifying based on all of your documents of everything that you have, that you've given the prosecution and the defense.
Yeah, but a lot of times when someone's receiving a so-called, if he is receiving a kickback, and it's not always reported.
Okay. So, if we accept your number, and you think you said 115,000, you thought Fabio was, and some change that Fabio really was getting from Silverboy, right?
That's based on the documents I reviewed. That's what I figured.
All right, so if we accept that number, then you put a value on it, and I won't go into the weeds of how you determine the value, but you put the value of the 385, all these percentages, right?
Yes.
Okay, well, still then, even if it was 385,000, that's still community property.
Well, there was a thing on the, if you look at the income tax return on the Schedule C, for some reason that return shows the LGI Consulting was in Monica's name.
It's still community property though if you divorce.
Yeah, I don't know.
Okay,
I
so
can't
you don't know that
test.
either.
Well, I wasn't asked to look at that or anything like that. But all I could say is that the 385,000 was the value. That's all I'm doing right
So
here.
you didn't know about the community property, but you just took the higher number.
The lower number.
Well, 385 giving more for.
No, I had 575,000 was the higher number. 385 was the lower number.
Towards a benefit for divorce, right?
Yeah, towards a benefit of divorce.
Yeah.
Correct.
Community property in California. So really, if we accept your number for divorce, it gets higher.
Yeah, whatever it is, I'm not here to.
So that's not. Well, I'll move on. All right. Lastly, nothing's factored in here about life insurance.
That's
Are you
not
aware
true.
that she stood and stands?
Objection, Your Honor, it's right on.
It's not true what you're saying. You asked me a question. The $720,067 is already incorporated in the chart. No. Go to the right. I'm sorry, to the left.
Yeah.
It said life insurance proceeds, $727,067. I'm not making any corrections or adjustments on
You
that.
haven't done anything with life insurance, right? You haven't incorporated anything
Correct.
with life insurance.
That's correct.
Okay, so that's, at the end of the day then, with life insurance, then she still has $720,000. If her husband dies, she gets it right then for life insurance, right? You're not disputing that.
I didn't make any comments to it.
Are you disputing that now?
I have no comment.
All right, any more questions?
Anything further indirect?
Yes, absolutely. Let's put this chart back up here. That's benefits. 26. 126. Your calculation on LGI was how much, Mr. Rubin?
$385,000.
And Ms. Stagel went into many questions about, isn't that too high? The kickbacks might be less. He should be getting less. It's community property. How much did Ms. Eversbacher put up there as the amount from LGI that she considered under the divorce category?
There is no amount. She didn't incorporate it. All she had was for what was on the bank account of $9,464, but failed to include LGI Consulting as an asset itself, which is the present value, the future cash flow, the estate. If Fabio was alive, the monies that they would have received, the value of that was $385,000.
Let's not even consider as exact the figures you gave as to how much more money would have come into that account had Fabio lived. Under divorce, you see the amount. It's right in front of you on the little screen.
Right.
You see the amount, $4,000. You see that?
Yes.
So Ms. Eversbacher said the benefit to Monica Sementilli had she divorced her husband was $4,000. Correct?
Yes.
How much money, by your conservative estimate, was going into the LGI account as a result of this kickback from Wella?
Objection, speculation.
Hello.
I believe
Objection also seems facts on the evidence.
Well, that's what now the parties now refer to this item. I'll allow this. It's overruled.
I believe from the time period of May 1, 2016 through April 30th, 2017, it would have been approximately $115,000. And the year before that was approximately $360,000. I'm sorry, it'd be $360,750 times 20%, which would be about 660 times 20%, 72,000.
So you looked at how much money was coming from Wella for Fabio's app that they were using in the prior years before his death, correct?
That is correct.
What is the average amount that was coming into LGI for each year? Approximately.
Well, the thing is, like,
Just approximately. How much money was coming in from LGI to LGI according to those records from Wella?
well, according to the records from Wella, let me give you a breakdown so you can better understand, because it's
Okay.
you can't because there's significant increases in revenue each year. It grows. Like, for example,
What's the lowest to the highest?
the lowest is in the beginning.
Which is what?
Wait 1 second. So we have the time period from May 1, 2013 to April 30th, 2014. A Scissor Boy would receive $34,000, and so LGI 20% of that is about $7,000. Then you get into May 2014 through April 2015. Scissor Boy received $194,000, so 20% of that is around $40,000. Then you go from May 2015 to April 2016. Scissor Boy received $360,000. So LGI would have received around $72,000. And then you have May 16 through April 2017. Scissor Boy received $578,000. And so 20% of that is $115,000.
So for those years until the death of Fabio, what would the average amount that LGI was getting from Scissor Boy? Approximately.
Well, there's been significant increases in growth.
I understand it's probably going to go up, but I want to be conservative.
Sure.
What's the average amount?
I'll use 60,000.
Okay. So the average is $60,000 coming from Scissor Boy to LGI while Fabio's alive.
Right.
And your figures indicate that it's much more because it's been going up every year, correct?
Well, especially the last year.
Okay, fine. So, if Monica Sementilli had stayed married and they got divorced, even with community property, half of that, the money would still be coming in from Scissor Boy and they would split it, correct?
Correct.
And the least amount was $30,000 and the most amount, if you split the last year, what was the last year?
The last year was $115,000.
So it becomes $60,000, correct?
Yes.
And Ms. Eversbacher put the amount for LG Consulting as $4,000, correct?
Yes.
In other words, and then it all stopped when Fabio died, correct?
Yes.
Scissor Boy said, we're not paying any more because it was dependent on him being alive, correct?
Yes.
And then your records show they made a new contract without Fabio with Wella.
Yes.
So forget about that. If Fabio lives, they're getting an average of $60,000 a year. If Fabio dies, they're getting nothing, correct?
Yes.
And they got nothing. Monica got nothing in the last 7-8 years from Scissor Boy to LGI, correct?
That's what I believe, yes.
All right. Now let's go back to the options. Let's assume for a second, and I hate to do this to you, but we'll just assume that your company overlooked these options, made a mistake, didn't exercise them until they were notified by P&G. I assume your response would be we would have found them one way or the other, correct?
Yes.
But let's assume you didn't find them until you were notified by P&G. All right? You
Yes.
assuming that?
Yes.
So if you look at the chart, had Monica exercised the options when Fabio died, upon his death, she would have gotten what, $43,000?
No, 74,000.
$74,000. And your company, by waiting until 2023 or 2022, got $900,000 for the estate, correct?
More than that, yes.
So if you eliminate any negligence or anything on the part of your company, which I'm sure you would claim, by waiting to exercise these options 5-6 years later, the amount went up from 70,000 to 900,000. Is that right?
To higher than that, yes.
Okay. And during that time period, from the time that Fabio died until the time that you exercised the options, Miss Sementilli did not ask to exercise any of those options, did she?
No, she did not.
So on the date of death, if this was and you looked at this as a death versus divorce option. In other words, is he worth more dead or alive, correct?
Yes.
Put it bluntly. So on the day of his death, she could have exercised the options on that day, right?
Around that time, yes.
And would have gotten $70,000?
Approximately. I mean, the stock may have come up or down within a 2-3 month time period, which would have probably
All right.
taken to exercise it and cash it out.
She could have exercised them right away in February, or March, or April, or May, or June, correct?
Yes.
Did she?
No.
And they kept going up. Did she exercise them in 2018 or 2019?
No.
Okay, she was arrested, we know that, and in jail. So, what you did is simply take the amount that the options were worth when he died, correct? On the
Ye-
chart.
Yes, that's correct.
And what Ms. Eversbacher did is took the amount they were worth in 2023 or 2024, correct?
Yes.
But at the time he died, Ms. Sementilli never tried to exercise the options, right?
Not that I'm aware of.
So, had she gotten divorced, the options still would be going up every year, correct?
Yes.
And whenever they exercised them, if they did,
If they didn't exercise them, that's correct.
and if they waited until they were finally going to expire, which we have to assume they would have, then they would have split $900,000, correct?
Whatever the amount, it would be something of that amount.
So, and we'll go to alimony. I understand that those figures can be varied based on many factors, correct?
Yes.
But Ms. Eversbacher had no amount on there for alimony, correct?
That is correct.
The most money, would you agree, that someone in divorce is going to get from the spouse is due to alimony?
Objection, speculation.
One of the amounts that they're going to get is due to alimony, correct?
Sustained.
Right? Have you ever had a case where someone making $250,000 or more and a 20-year marriage would not get any alimony?
Objection, relevance.
Sustained.
Was there even any lower or higher end for alimony on that chart?
No.
In your opinion, based on your experience with divorce cases, is alimony at least one of the factors to consider when someone is determining what the wife will how the wife will be financially in the next 10, 20 years.
Yes.
Did Ms. Eversbacher have any range or any figure up there at all?
There was no range and no figure.
So let's set aside any issues of your competency or not competency, and let's just look at the chart, black and white. When it came to LGI Consulting, because Fabio died, they lost at least $30,000, $40,000, $50,000 a year, in your opinion, correct?
Yes, probably more.
And concerning the options, had they been exercised at the time of his death, it would have been worth $70,000. Is that correct? About.
You're getting very cumulative now. We've gone through all of this.
Okay.
You're just using different words now.
If the options had been exercised at the time that Fabio Sementilli was murdered by his wife, you have the figure up there as what the options were worth, correct?
It's not on this chart, but it was on the other chart.
Okay. And in your corrections, all you did is take that amount and subtract it from the amount that Ms. Eversbacher used, which was the amount they were worth in 2023. Is that right?
2024, yes.
2024. And she put that up as an advantage of death for Ms. Sementilli, who you know at the time of the death and up till the time she was incarcerated, never made an attempt to exercise any of those options. Isn't that right?
Yes.
Thank you.
I will be brief. All right. Going back just briefly on the LGI system again. You chose to use 20%, not necessarily 20%.
It was an estimate.
Okay. And then again, we're back on that 115,000 again, telling you to assume that the deposits, if you look at their account, 61,000. So that's a difference. So you're already starting with
Wait.
an incorrect number, correct?
So, can I go back and explain? Because as I was going through this chart and getting the figures, if you look at, so there's like an overlap. Because the way I calculated was the time period of May 15 to April 2016. So if you look at during that time period, the amount received by Scissor Boy was $360,000. 20% of that would have been approximately $72,000, which is close to 60. So, maybe it's 18% or something like that. I mean, but it's close.
Okay. So
And in fact, the prior year, I think it goes the other way. So
right.
Anyway, go ahead.
So then that was the correct number, the 61, not the 115.
No, that's not what I said. The 115 incorporates time period after Fabio had died as well. And so after he died, there was approximately several $100,000 that was received, and so it was $578,000 between May 2016 and April 2017. So the revenues were increasing significantly and went 60% higher than the previous year, which is how the 115 became about. So that number would not show up on the tax return.
Okay. I want to move on because, again, 3,000, 125 a month. That's Fabio for.
That's an email from someone who lied.
Oh. Okay.
He lied to us. He sends an email.
No question
He sends that email to Monica.
No question pending. Okay, so so that was a lie. All right. So,
Well, wait.
No.
You said so that is a lie. She asked the question. So if that is, I'll explain that's a
This
lie.
isn't tag back. This is a court of law.
She's just
Sir,
okay. She tells him what. Sorry.
all right. Now, as far as stock options, and I am almost done. I know everyone's happy about that. As far as stock options, again, you testified, and defense was asking you questions just now about she could have gotten $74,000 the day he died because they vested, right? So she could have gotten all of her stock options, which were valued at that time the $74,000 in 2017 because they're vested because he died, right?
Yeah, plus or minus if it takes a few months to go through the process.
But in opposition of what Mr. Levine said, if he didn't die and she just divorced him, some of those, most of them, the remaining 4 of them weren't vested. 3 of them. They weren't vested. She doesn't get those.
We went through this now.
Well, I'm saying, she doesn't get those.
I'm going to object, Your Honor, that, well, I'll wait till you direct.
The point is on redirect, you agreed that she would get them if they divorced, but if they're not vested, that's not community property anymore. Right? Correct? Yes or no?
But Fabio worked there.
Correct? Yes or no?
I can't answer that question right now because I need to see the plan documents to have a better idea.
And then as far as getting the $70,000 if he died, we talked about them increasing in value. But you're aware that if he died and she was able to get those stock options at $74,000 because he died, and she didn't do it then, right? She could have, but she didn't because he died. Right?
Wait, say that again?
She had $74,000 worth of stock options because he died that she could have exercised, and defense counsel saying, but she didn't. She could have, but she didn't. Right?
I don't know if could have is the right answer because if you don't know about something, then how can you do it?
What you don't know about, or what she?
No,
doesn't
what she
know about?
I don't know what she knew or didn't know.
That's the same
So the
Okay.
premise of the question is
All right. But were you aware that she was trying to get $720,000 from life insurance? So $70,000 maybe wasn't at the top of her mind. She didn't need it at that point. Do you understand that?
Objection, that's already made.
It's the same.
I have no more questions.
Any further?
Are you aware of emails that were sent between, who is Justin Gold?
he's my attorney.
And is he the attorney for the estate?
Yeah, he's the attorney for the co-administrators of the estate.
And you're aware, I take it from emails, that he's been in constant contact throughout this litigation with Ms. Silverman of the DA's office, correct?
Yes.
And promised to cooperate in every way that she wanted, correct?
Objection, speculation.
Sustained.
All the information that you have put up on this chart or testified today, if you had been contacted by the prosecutors, as Mr. Gold was, would you have supplied them with all the information you supplied to me?
We have been contacted by the DA's office, and we supply them with their information request, just as like we supply you with your information request.
So everything you've testified has either been supplied or would be supplied upon their request, correct?
Whatever's been asked of us, we supplied it.
You didn't play any favorites one side or the other.
No.
And those vesting dates, let me try to understand it. Because he died, the option automatically vested, correct?
Yes.
If he had not died, they would have vested within 3 years of when they were issued, correct?
Yes, and even Ms. Eversbacher had applied that there were amounts that Monica would have received in case of a divorce. It was in her chart that Monica would have received if there was a divorce.
So the first options were 2015. They would have vested in 2018, correct?
Most likely, I haven't seen the plan documents, but presuming.
And the other ones,
before,
other ones in 2019, correct?
yes.
It's all 3 years later, and the other one's 2020, correct?
Well, those options would have been granted in 2017, so it would have been whatever was outstanding. If it was 14, 15, and 16 were the ones that were outstanding that were vesting in 17, 18. I'm sorry, would have probably vested in 17, 18, and 19.
Oh, so by 2017, some would have vested. By 2018, some would have vested. 2019, correct?
That's correct.
So if they gotten divorced, she could have exercised them as community property in any of those years, correct?
Yeah, according to Ms. Eversbacher's chart, there were applications of funds that would have gone to Monica of those proceeds. Application of proceeds that would have gone to Monica.
Okay, but upon Fabio's death, she's the only one who could have exercised these options at that time, correct?
Or through the estate, but yes.
Right? And they were all available to her from the date of death. They all vested, correct?
Yes.
And in 2017, 18, 19, did she seek to exercise any of those options? No.
He answered.
Thank you very much, Your Honor. Thank you.
Anything further?
Well, no.
Let's take about 10 minute recess. That doesn't surprise. See you after 10.